Hello, welcome to episode 4 of Constitutional Soundbites, put together and presented by SAT Media through the good offices of Josh Alvarado and his team. We're so happy to be bringing this to you. This is, as I mentioned, episode 4. Last episode, we really kind of concentrated on the founding period, kind of between when the Declaration of Independence was issued and when the Constitution itself was adopted. Moving along from that, we're going to talk about some of the concepts that are in the Constitution. And everybody hears about the idea of separation of powers. I don't know that many people spend much time on where that came from, why the idea exists, and how important it is to our liberty and freedom. In terms of constitutional soundbites, this book that I wrote, we've got 150 questions and answers, and it's kind of an interesting exercise because all the time, I don't know, even if you haven't written a book, almost everybody's written something, a school paper or things of that nature. And the fact is one of the toughest things to do when you're doing any of that is what to leave out, because you often learn much more than you can put together and present in a situation. And that's the value, I think, of what we're doing with Constitutional Soundbites, is because this book has, as I said, 150 questions and answers, basically short answers. But I learned while creating this book and studying the Constitution, I learned much more than I could put in the book. And so we're having an opportunity to expand upon the things in the book. The next question that I had for anybody that's interested is on page 10 of the book, if you were to get the book. And that is, why does the United States have 3 branches of government? That I think it's worthwhile not just to know that there's 3 branches of government, but to know why there's 3 branches of government. And through history, it had typically been a situation where essentially there was one man or a small group of men. If it's one man, we kind of consider it a monarchy. If it's a small group of people, we kind of think of it as an oligarchy that would control all the functions of government. It was largely defined, at least the definition that was followed by the founders, was by a Frenchman. His name was Montesquieu. And Montesquieu was the one that actually explained in some detail about the value of separating the legislative function, which is the lawmaking power, the executive function, which is enforcing the law, and the judicial function, which is interpreting the law. And that is that if there's only one person or a small cadre of people who do that, you don't really even have law, right? There's nothing dependable. It's based upon the whims of these individuals that are involved in creating, executing, and judging the law. When you have what they call judge, jury, and executioner, that's what you have if you don't separate these functions of government. And there's a important work in the mid 18th century that Montesquieu put together. It's called The Spirit of the Laws, and it was something that James Madison relied on heavily in his recommendations on how to organize the United States government during the Constitutional Convention. Montesquieu clearly defined these 3 government functions and argued that separating these functions would best protect freedom and liberty. And the Constitution's framers agreed with Montesquieu. So I think it's important, again, not just to know that these powers are separate, but to know why. And the why is that if you put them all together in one hand, you do not even have law. So this is what we need to do with it. And when we're talking about these things, this is kind of some of the problems we're facing these days. Some of the problems we're facing these days have to do with these governors, mayors, county board presidents, the fellow that sits in the White House these days, acting as if they get to make the law, enforce the law, and judge the law as well. And they don't like it when other people impinge on it. We've allowed some of this to happen too much in that direction, and that impinges on all our freedoms. Let's just momentarily. Do you have a question, John?
Yeah, I think that makes a lot, that makes a lot of sense, right? Because, when I was in school, all they ever told us was there's three branches of government because the other ones check on each other, right? And, they never really elaborated on that, at all. So.
Well, and here's a good example of the illegality that's taking place in the state of Illinois at the moment. And that is that there's something called the Illinois Emergency Management Act. The Illinois Emergency Management Act permits and allows the governor to issue a disaster declaration, and during a period of 30 days following that issuance, he can exercise extraordinary powers that are in a normal circumstance the governor's not allowed to exercise. And the law calls for, during that 30-day period, to go to the legislature and present the issues of this disaster to the legislature, and then have input from the legislature on how to deal with the disaster. And that was the state of the law in Illinois in March 2020. And so he issued his first disaster declaration and did not particularly like the state of the law. Did not go to the legislature, however, simply went to the current Attorney General and said, Mr. Attorney General, I'm not liking this very much. I can only do this for 30 days. So the Attorney General went and said, no, I'm going to issue a new opinion that says you can do it 30 days and then 30 days and then 30 days and then 30 days. And we are now in the 24th, I think, executive order. We're coming up on the 24th. In February, it'll be the 24th. Executive order, by them pretending that the law changed. The law never changed, but these guys pretended that the law changed. And so now you have these folks that are making up the law, issuing orders for which there's no legal basis or legislative authority because they didn't go to the legislature within those 30 days. And so consequently, that's the problem, because they've now when a governor issues these statements that start with whereas, and if you missed the last segment, there's a long discussion about how whereas comes from kings. Kings issue whereas statements, and governors, presidents, mayors, county board presidents, none of them are in a position to issue a whereas statement to an American citizen. And but now they're continuing to issue these, and when they do the whereas, then they talk also about the penalties that they're going to impose. They also talk, so now they're being the judiciary as well as the legislature as well. So they are consolidating the authority within the hands of very few individuals. And let's just say momentarily, if the governor had in fact gone to the legislature within the first 30 days, we would have had hearings by the legislature through the representatives of the people, investigating things like whether children are going to be hurt emotionally, physically, or otherwise with masking, let's say. Whether or not the impact on the economy would be balanced against the risk of leaving the economy open. Those things would be investigated by the legislature, and then have input from the representatives of the people, rather than one individual relying on whomever he chooses to rely upon, saying this is one size fits all. And we've seen a lot of destruction of religious liberty, impingement on religious liberty, impingement on parental input on what happens with their children. I would suggest that if the governor had in fact followed what the law actually says, and that is go to the legislature and have these powers separated the way they were designed to do. And by the way, in the Illinois Constitution, there's a separate specific thing talking about the separation of powers. So there's a specific constitutional provision outside the U.S. Constitution, but rather within the Illinois Constitution. We would not be facing a lot of these problems because it would have been put together and organized according to the representatives of the people, rather than being imposed by a single individual who is commandeering our entire system. They've actually issued orders to judges. They actually issued orders to judges impinging on the independence of the judiciary. I was in court, And I was looking up, went to look up the case that I was involved in, and the court, and typically it says, so-and-so versus so-and-so. But the court printout on the day's record says sealed. The governor issued an executive order indicating that when it comes to eviction matters, it was no longer to be a public record. And he actually issued an order to the judiciary to seal public records across the board. There's no authority for him to do such a thing, but he's exercising the judicial power under. When our founders talked about tyranny, this is the kind of thing that they talked about. And so it's appropriate for us to kind of get there when we're in the Stand Against Tyranny Media Center, if you put it that way. So, yeah, it's important for people to understand not just that there's three branches, or just that there's separation of powers, but why? Right. This is our problem. We don't know the whys. We don't teach critical thinking as we should, so that people will question things and come to an appropriate disposition of matters, because the one size fits all, or the opinion of one guy is not what we signed up for, And so for people to understand why that's the case, and one of the other problems it turns out to be is that these folks that have assumed these what we call ultra vires powers are impinging on so many of us, and they've tried to separate us by who will follow their orders and who will not. There's the people that refuse to follow the orders just because even if perhaps maybe some of the ideas that Pritzker put together, maybe some are good, but the fact is they come from one guy, and so that inherently is not good. That inherently is dangerous, because even if let's say for momentarily he's a benevolent dictator, he's still a dictator.
Yeah, no, I agree. I didn't vote for Emperor Pritzker. I mean, I didn't vote for him in general, but I did not vote for him to be king of Illinois. So, and I don't think anybody in Illinois did.
Yeah, no, I'm quite certain that nobody voted for him to be king of Illinois, and he's literally declared himself as such, and some of the other government, and that's a profile of lacking in courage by some of the other people that hold office elsewhere within the state, because certainly, while he did not go to the legislature, there is nothing that would prevent the legislature themselves from acting. But they are not acting themselves; they are submitting themselves or prostrating themselves to the king. Right. This is, so now we've got what I mentioned in the last episode is like an oligarchy, at the very least. And so this is why things need to be separate, and this is how our liberty is protected. You need to be able to go to an independent third-party magistrate in one situation, and in the other circumstances, this guy who's making up these rules should have the input of people that are directly responsible to us through elections. And I would hope that this coming year, November 2022, the people of Illinois will understand that and say, who among you that's holding office has stood up for us? Who among you has stood up for us? There's too many people in office for whom it's not public service, but it's the family business. Right. And when it becomes the family business, they're not working for us. They're working for their own entity. And that's the important of, because the idea is that these powers, these different branches of government, they're not supposed to work together. They're supposed to check and balance. They're supposed to be in conflict. When people say, well, they're not getting along with the governor, that's fine. It's okay that they don't get along with the governor. They shouldn't. They should disagree with the governor. And when they do come to us and say, well, this is a bipartisan agreement, hold on to your pocketbook, from that perspective, because a bipartisan agreement means that everybody got together and figured out how they're going to spend our money. They try and sell that as a big thing, if they can attract votes on both sides. But they attract votes on both sides here in Illinois on a way that is likely unconstitutional, because Illinois has something else called in their constitution. And maybe we'll have to do some segments on Illinois Constitution specifically. Yeah. But there's something in the Illinois Constitution called the single subject rule that says you can only have one matter involved in a particular piece of legislation. And the legislature violates that all the time. And they violate it so that they can trade votes on different matters and trade the spending. And they say, well, I'll build you a bridge here if you want a police station over there, et cetera, et cetera. That's all violation of the single subject rule in the Illinois Constitution. All of it should be unconstitutional, because the idea of the single subject rule is that each legislature has to stand up and say, yeah, I'm for that police station. Yes, I am for that bridge, as opposed to saying, well, there's a lot of good things in the bill, and I don't like these here, but I like these here, and on balance, it's a good piece of legislation. No, that's not how it's supposed to work. That's, in fact, under the Illinois Constitution, that is, in fact, illegal. And we don't have anybody that enforces that, because all the people that are in positions to enforce that benefit from violating it. And so that's something to be educational. I know we're going to have, I presume from time to time, there's viewers outside of Illinois. I would encourage them to take a look at their own state constitutions. This single subject rule within state constitutions is not uncommon. And if, in fact, it's regularly violated in your state, this is something you need to call the attention of your legislatures. And I would, I'll just mention, I come to study some of these things a little more as a candidate for Illinois Attorney General. And I believe the Illinois Attorney General, it may be the very particular office that has the authority and the ability to enforce that constitutional provision on behalf of the people of the state of Illinois. So we're so essentially enforcing the separation of powers that we started this discussion with. Oh. So there's the implications are just so huge, Josh. When we don't do that, we lose our freedom and we lose our liberty, and that's kind of where that whole discussion goes. We've gotten a few places, so we're having a good time. I hope our viewers are having a good time, and we're so lucky to have the SAT Media facilities to do that. And please be in touch with either me via my Facebook Messenger, or Josh via his Facebook Messenger, or the Illinois Standing Against Tyranny site. Send us messages about if you're enjoying any of this, or if there's particular areas that you think we should cover. Because again, this is, as I started out, we're only actually covered one question again in this circumstance, because while the book is designed to give you good information in short little what we call sound bites, again, like I'm sure like you did when you were writing a term paper, and when people are going to school, or when they prepare to get on do a podcast, you always know much more than what you're able to convey within that media in that time. And this is an opportunity to expand upon things that are in the book and bring additional information to folks. So thanks again for joining us for episode 4. Is that where we're at now?
Yep, that's right, episode 4.
For episode 4 of Constitutional Soundbites, brought to you by SAT Media. And we look forward to joining you again. And soon, I hope, in coming next episodes down the road, I think I'll be joined again by my co-host, if you will, Matt Skitza. So thanks again for tuning in. We'll be back with another episode of Constitutional Soundbites soon.